welcome to National Whistleblower Center's False Claims Act celebration, which is also co-sponsored by Whistleblower Network News. Thank you so much for joining us today for this live event, which is a preview of what you can expect for National Whistleblower Day 2020-2022. I'm here with some expert attorneys, and I can't wait to dive into the conversation with you. We'll be having a live Q&A that starts at 3:30, followed by a keynote by Senator Grassley about the False Claims Act and why we need to continue improving it. So we'd like to kick off with some remarks from Neil Henrichsen, who is from Henrichsen Law Group, and he is the wonderful counterpoint that we've been working with at NWC, supporting us in making sure that we can help connect whistleblowers with attorneys. So we're really proud of this program, and we know that so many of you reach out to us for help, and this is how we are able to help you and help as many people as possible. So thank you. And Neil, please share about the LAP program.
Very good. Thank you, Siri. My name's Neil Henrichsen. For over 30 years, I've been an attorney representing employees and whistleblowers throughout the United States litigating cases. I have the privilege of working with the National Whistleblower Center's Legal Defense and Education Fund's Legal Assistance Program, the LAP program. We know that whistleblowers encounter unique challenges and legal issues in dealing with their workplace situations, in dealing with their activities as whistleblowers. Whistleblowers often have difficulty connecting with skilled and experienced lawyers familiar with the challenges with a whistleblower encounters. The laws we know are vast. We're here today celebrating the False Claims Act. We know that has terrific anti-retaliation provisions, but whistleblowers could also be covered by other federal laws, state laws, local laws, and the anti-retaliation protections that those laws have. Luckily, the fund provides a resource for whistleblowers, a voluntary program where a whistleblower, such as a government official, executive, employee at any level, can fill out a form online at whistleblowers.org. The whistleblower's information is kept confidential, it's vetted, and if appropriate, they're referred to a network of attorneys who are experienced in whistleblower law throughout the United States or legal organizations that are related to the protection of rights of employees. If you have an interest as an attorney in becoming involved in this program, which is an important resource for whistleblowers, you could call me directly. Again, Neil Henrichsen, 202-423-3649 is my number. You could fill out, if you're a whistleblower, an employee, anyone having questions, go to whistleblowers.org and their information forms on there. So we look forward to hearing from you. This has been an extremely important resource. You'll see all the good the program has done throughout the years. And we encourage you, again, whistleblowers.org to go to the website and take advantage of this excellent program. Thank you.
Sorry. Thank you so much, Neil. I'm so happy you were able to be here to speak about the legal assistance program and the fund and the great work that you all do connecting whistleblowers with legal representatives. The False Claims Act is the first whistleblower law of the United States that was enacted by a president. President Lincoln enacted the law 159 years ago. It's been improved throughout the time that it's been in existence, and it's the most utilized whistleblower tool that we have in our arsenal. So I'm so happy to have our extremely, extremely knowledgeable and outspoken advocates for whistleblowers and experts in the FCA here for our panel about the FCA and how it needs to improve and their personal experiences as attorneys. So I'd like to kick it off with Jeb White of Taxpayers Against Fraud and hear a little bit about him and his legal experience.
Yeah, thank you, Sarah. Really appreciate it. The False Claims Act has been around 159 years, but the Modern Act has been around 35 years. It was revitalized because of Ronald Reagan signing into some amendments, but it was shepherded through Congress because of Senator Grassley and Congressman Berman. 18 days after that happened in 1986, Taxpayers Against Fraud was founded by our founders because they recognized that there was going to be a push from the other side to undo everything that Congress put in place. This was during the time of the $900 hammers and the $3,000 toilet seats. And the other side came soon after to try to undo what Congress put in place. Taxpayers Against Fraud and a number of other organizations, including NWC, has been standing strong to protect the False Claims Act ever since. So I'm currently the president of Taxpayers Against Fraud. I was previously in this role from 2007 to 2010. Then I spent 10 years in private practice representing relators under the False Claims Act. And then during the pandemic, I came back to my old role, Taxpayers Against Fraud. It's an interesting / fascinating / scary time for our country. But as long as anti-fraud laws are in place and strong whistleblowers are incentivized and protected, we have a chance to recover stolen dollars and protect our public fisc and our patients and our citizenry from those that seek to do harm. So I really appreciate you including me. And this is a great anniversary. I look forward to the next 159 years. Thanks, Siri.
Thank you so much, Jeb. And I also want to point out that you all have a great publication that you put out quarterly that people can read about False Claims Act litigation. And you're on social media. You're on your own handle at Jeb White, and you're also the Taxpayers Against Fraud handle is a little bit unpredictable, isn't it? Like Fraud in America or something.
Yeah, so I mean, I'm glad you brought that up. So we are a membership organization of over 300 whistleblower attorneys from across the country. So we're a membership organization in addition to representing whistleblowers. We put out legal publication. We hold conferences, webinars, events, retreats, things like that too. So yeah, we have a lot of things going on. But we also have a podcast and a YouTube show called Fraud in America. Hence our handle.
Okay, yes, and you also have a Young Lawyers Division, which I am a member of. So I appreciate all the great things you do. And if you're on Twitter right now, you can follow our live tweet at Stop Fraud and hear more about the conversation, our great quotes. So Erica, let's hear about your wonderful work.
Hi, thanks so much for having me. I am one of the many members that Jeb referenced, have been for the last several years prior to that. So I work, I am a partner at a Whistleblower Law Collaborative based in Boston, but it's a nationwide practice. My entry into the False Claims Act was immediate when I landed my dream job at Department of Justice in the civil fraud section as part of what they call the honors program, which really is basically entry level. I was coming out of a district court clerkship, which thankfully introduced me to the False Claims Act as well. A clerk for Judge Patty Saris, who handled a large docket of False Claims Act cases. So I at least knew what it was when entering the Department of Justice, but I did not when I was in law school, and I'm working to change that along with many other whistleblower and defense counsel teaching classes at different law schools. I know Siri, you do as well. I currently teach healthcare fraud at Boston University School of Law, and one of my partners teaches whistleblower law there. And so prior to coming to Boston to join Whistleblower Law Collaborative in 2018, I worked for about 9 years in the department, as I mentioned, first in DC in the civil fraud section as a trial attorney, working False Claims Act cases around the country. And then I had a personal reason to move out to San Francisco and took the opportunity to join the U.S. Attorney's Office there, where I had an excellent, what they call ACE department, affirmative civil enforcement, which did and continued my work in in False Claims Act work. So it's really been my specialty area that I somewhat fell into and love. And so that's been my experience.
That's fantastic. And Erica, where can people find you and your firm on social media? It looks like you're on LinkedIn, but anywhere else?
Yeah, I will get back to you on Twitter. I think we're actively going to be retweeting. So generally, if you watch Whistleblower Law Collaborative on LinkedIn as well as Facebook, and I'll chime in a moment with the Twitter handle. I don't manage that one. It's out of my pay grade, but I'll get it for you in just a moment.
Okay. Well, speaking of Twitter, we can go to our fantastic Twitter famous Dave Colapinto, who's also a mentor of mine and a good friend. So I'm so happy he's on the panel with us as well.
And I'm happy to be here. Siri, thank you very much, and for everything you and the Whistleblower Center does. And thank you, Jeb, for everything that you and your organization does. It's absolutely critical and vital to keep the False Claims Act alive and relevant and effective for whistleblowers. And I'm David Colapinto. I'm one of the founding partners of Kohn, and Colapinto, a whistleblower law firm in Washington, D.C. My two law partners and I, Michael Kohn and Stephen Kohn, started our law firm in the living room of Mike Kohn's house back in 1988. And since then, our firm has grown. We started representing whistleblowers in retaliation cases, mostly at nuclear power plants. And then we started representing federal employees in whistleblower cases, et cetera. And eventually, we came to discover the False Claims Act. And since that time, you know, it's like we are now devoting most of our time to representing whistleblowers under the False Claims Act, or since Dodd-Frank Act was passed and the IRS law was passed, representing whistleblowers in award cases, not because we don't think that retaliation cases aren't important and don't have merit, but when you're looking at you know, how you can be effective in protecting whistleblowers, these reward laws, starting with the False Claims Act and the 1986 amendments, are far more effective in protecting someone's employment than simply going into court and getting back pay and a reinstatement order that will never be honored and ends up being you know, a settlement of some sort where the person ends up leaving their industry or career. And so we've devoted our work to that. Also, my law partners and I helped found the National Whistleblower Center around the same time that we started the law firm, and now it's in very capable hands with Siri and a professional staff there. And I spend very little time working with the Whistleblower Center, but in almost 100% of my time is now in my private law practice. But Siri has continued on with the Whistleblower Center, and you heard from Neil earlier regarding the Lawyer Assistance Program, which is really important to line up lawyers with whistleblowers. When, you know, people often laugh when they hear me say there aren't enough lawyers. There aren't enough lawyers for people who need them, like whistleblowers. There are so many whistleblowers who proceed pro se, and there's no way that my firm or Erica's firm or all the members of Taxpayers Against Fraud and other organizations can meet the demand. So when I hear that, you know, whistleblower law is being taught in law school, that's like music to my ears, because we have such a great need in this country to represent people in these cases.
Such a good point. And tell people where they can find you on social.
Oh, social media. You mentioned my Twitter account. It's sort of like every morning, one of the first things I do is post a few things of relevance on whistleblower topics and other topics. If you care to read them, it's at @dcolapinto. That's my handle on Twitter. And our law firm also has a Twitter account at KKC Whistleblow, but I post directly on my handle, my personal handle.
And your Twitter is great. Erica, do you want to share your firm's Twitter now that you have it up?
Yeah, absolutely. Whistleblow LC, right? So that's our firm. You also find we're quite prevalent on LinkedIn, Whistleblower Law Collaborative LLC, or Whistleblower Law Collaborative, where we were promoting this panel and others. So we like to get up blog posts and then share those on social media. We love recognizing the work of the Department of Justice when they bring home settlements, and the Relators Council, even if not us, who were behind that, and the brave whistleblowers as well. And I'm always keeping an eye out so I can try to stay current for news, like David said, for whistleblower items, you know, whether it's just recent policy issues, right? The pandemic fraud, things that are mentioned in the State of the Union that might suggest oncoming initiatives, things like that. So we do our best to keep up. And I will put a plug in. I have to say, I've been listening to the Fraud in America podcast, and Jeb is doing a fantastic job. I'm using some of it in my class. The blog posts there are excellent as well. I've been really heartened and really impressed by what they're putting out. So now I'll have to check out David's individual Twitter feed.
Yes, David's Twitter is amazing. But I love how we're all so educationally oriented, and this panel is going to be so informative just based on our pre-discussions. So I want to jump into some of the more personal stories that you have as attorneys working with the FCA. And I'd love to hear a story of an FCA case that you will never forget. And tell me about how that impacted your practice. I'll start with Erica.
Putting me on the spot first, no problem. You get an attorney, you ask an attorney for war stories, and you're asking for trouble. But I'm going to share a case that those who have been in this world have known as a Ruggs case. Really, what that involves is fraud through the FCA, prosecuted through the FCA, the case, but fraud by a skilled nursing home. And in this particular case, it was a nationwide presence. So it resulted in a $53.6 million recovery, which, as a DOJ attorney, I was really proud of, but was really not what drove us the whole way through this case. Just to set the stage, this was one of many cases in this arena for a period of time. The general gist is that it was a practice throughout the industry to put profit over proper medical practice as a theme we've obviously seen before. But here we're talking about, unnecessary and sometimes harmful therapy provided to the most vulnerable patients, right? And in particular, even within the nursing homes, often the recipients of this care, quote, care, were the most vulnerable of the most vulnerable. And that is what drove us as we were working the case. And I was a DOJ attorney, learning the ropes and also growing in my own skill set. But, what stands out to me now as I reflect back on it are a couple of things, three really. First is that this issue was brought to the government by 5 separate therapists, right? So the on the ground people who went into this work simply to help, right? They're not high paid. They're not even often thanked because they're dealing with really difficult situations. They're the bottom of the totem pole, often scraping to get by, but they're in it for the right reasons. And all of these whistleblowers, right, come forward, and they were not unique, right? I'm talking about 5 for this case, but there were hundreds across the country in all the different cases that came forward, found whistleblower counsel, brought these important cases. And that's really what drove these investigations. And ultimately many successful recoveries from it. And so now, as somebody who has the privilege of representing whistleblowers, that is part of what helped me when I was stepping away from the government, come to this position, right? I wanted to work directly with those individuals and not only advance interesting legal theories and do the good work as a lawyer, but to put that. Also use the client counseling and honestly just be able to build that relationship with individuals like that. Second, this was a particularly long, hard-fought investigation, like all of those cases were. Involved a lot of medical review and a ton of witness interviews, a ridiculous amount of document review. But really, both our case, my team, but really DOJ as a whole stuck it out, even though they were getting a lot of attacks and maybe some challenges in court. To this theory of liability, because it was important. And that's really where I have to commend. There were certain individuals in the department that really prioritized nursing home care. One has moved on is Andy Penn. In general, with respect to nursing home care, is really driven to just make sure that the care individuals are receiving is appropriate. And then, of course, Andy Mao, who's the Civil Frauds Deputy Director right now, really laid the groundwork, both that I could follow, even though I was out in California, right? I had the privilege of working with him in DC, but I was able to understand how to build this case because of the work that he and others did. And finally, I think this is an example where it really made change, right? So in addition to a series of recoveries, because of the work that DOJ as a whole and HHS-OIG, obviously alongside of it for those cases and on its own, right, in terms of reports and audits that they did in addition to supporting the DOJ cases, really actually led to a complete overhaul of how the payment system works within the skilled nursing industry. And look, I think we all know that there's going to be individual or companies and others who are trying to now find the new workaround. So we have our eyes peeled for that, eyes open, but that is a real show of how it should work. And none of that would have happened had the False Claims Act not been there to give these therapists who, don't have tons of money to pay lawyers, or even if they hadn't, if the False Claims Act wasn't a required, and it isn't always, but it is in many ways, right, a required aspect of compliance programs and training, they may not have even known to call a lawyer, right? Or if they didn't have an underlying employment issue. So that's why I think this act just provides an avenue for frauds and problems that would otherwise just go unaddressed, right? It's not just an extra tool. It really is the sole path to protect some of our most vulnerable. So that really has shaped my view of lawyering and of the FCA as a whole.
That is such a great story that really represents the heart of the False Claims Act, right, Erica? Like, the False Claims Act is a law designed to hold fraudsters accountable for taking money away from the government and depriving taxpayers of the services that we should be paying for. And one of the provisions is the qui tam provision that allows individuals to come forward on behalf of the government when they see fraud and report it and work with the government to address the issues and recover damages on behalf of the government and ultimately the public. So the story that you told really does show individual action coming to fruition with cooperation with the government and resulting in wrongs being righted. So Dave, I'd love to hear from you about your experiences and a story that represents your work with the FCA and how it shaped your practice.
Sure. About a little over 10 years ago, I guess in the fall of 2011, we were contacted by probably one of the youngest clients I've ever represented. He was in his early 20s at the time, and he worked as a financial person for a company in New Jersey that, while he was working there, discovered they were involved in fake biofuels. And they ended up, so he was there to help invest what turned out to be the proceeds of the fraud. He didn't know it at the time, but the owner of the company was making more money than he knew what to do with, more money than he'd ever made in his life. And he had extra millions of dollars to invest, and hired our client to invest the money as a hedge against losses and things like that. And as our client came to learn about the business, he started asking questions. And more questions, like, how is this company getting this type of a profit margin on selling biofuels? I get that there's a tax credit. I get that there are energy credits, for like $1 a gallon on those things. But how are they really making so much money? You do the math and it doesn't work out. So he confronted the boss with these questions, and finally the boss admitted that what they were engaged in was a massive fraud on the government. And he said, we have a code word for this, and it's called alchemy. And basically the fraud scheme went like this. Instead of producing biodiesel at the plant that they were associated with out in Indiana, they would actually go on the market and buy biofuels that someone else had produced and already claimed the tax credit and the energy credit for, and then ship that into their plant, falsify paperwork, and then say they produced it and claim new tax credits and new energy credits and submit those claims to the government for payment. It was all a huge scam. He stopped it in the tracks. He got his cell phone and put an app on it and started recording conversations, which were very incriminating. Hundreds of hours of conversations were recorded. He comes into our office like, okay, so what kind of case do we have here? We certainly have a False Claims Act case because the energy credits were claims submitted to the government. So that's clear. We have a False Claims Act case, but also one of the conspirators in the fraud was a publicly traded company, a small oil company. So now we have SEC fraud. And then, of course, you got the tax credit angle. You've got an IRS whistleblower law. So we pursued all three avenues. And as a result of the whistleblowers' disclosures, the government decided to go criminal on the case and ended up calling our client as their star witness at one of the cases that went to trial. The whistleblower's boss ended up pleading guilty, and he's doing 20 years in prison right now. And he's doing 20 years in part because after he was arrested, he threatened to kill two of the witnesses in the case. And then the head of the publicly traded company got like a 10-year sentence, and he was stubborn. He had some resources. He went to trial, and our client testified at the trial. And after the client's testimony was finished, and I was sitting in the back of the courtroom, the prosecutor comes up to me and he says, I want to put you on the witness stand now, because on cross-examination, the government was concerned that perhaps the jury was confused about when my client had discovered or identified the voice of the defendant on the tape recording. So he wanted to clarify that. And he says, plus there's all this other implication that your client is in this for the money. And there, because that came out on cross-examination, you could get this huge whistleblower award and so on and so forth. Says, I want to put you on the stand to talk about the False Claims Act and how important that law is. I says, well, if you think you can get the judge to allow me to testify, sure, I'll go up and testify. So sure enough, the questions were asked and I clarified, the factual issue. And then they started asking me questions like, how important is the False Claims Act? Can you tell the jury what that is? I started talking about how Abraham Lincoln signed it and giving examples under that and all the rest of it, and why that was important under modern law to combat fraud. And so that's why that case stands out more than any other case I've done. That we just finished the False Claims Act piece of it. We're in the process of collections, and we'll get into, I'll discuss this case in more detail and answer to some of your other questions, because I think it will be a good example of these things. But though that's a case where, a young person recognized wrongdoing and fraud, collected the evidence, went to lawyers, and pursued the case.
That is such a fantastic story. Thank you. It really highlights how interconnected so many of these programs are and how important it is to understand the jurisdiction of each one of those programs and file with every applicable one, because you don't know what the outcomes will be. But also, I particularly love that you brought up a climate-related case, because when we talk about the False Claims Act, it's important to understand that this is a major avenue for making sure that our laws and regulations about climate controls and the programs that voters support that actually encourage people to have greener choices are enforced properly by making sure that people are following the rules. And the best way to do that is to have whistleblowers come forward when they catch someone, taking advantage of the system. So that's an awesome story. I love it.
Harry, I have to chime in just for a moment, because my first, I also struck me when you mentioned biofuel. My first case as a Relators Counsel came, and it's resolved now as a Massachusetts State False Claims Act, where Massachusetts was trying to encourage its public entities, and did, to go through the process to buy biofuel. And there was a particular biofuel company that was not fulfilling the end of their contract, allegedly. And therefore, that was my first, case. And it really was, part of what drove us and our client, right, was the environmental aspects of that, as well as the financial.
That's right. Voters support these programs, and they need to be policed to make sure that they reach the goals that we set out. Jeb, what about you? Let's hear about the taxpayers' interest, as we just mentioned.
Yeah, it's interesting as I look back. So prior to going to law school, I actually worked for a very large financial institution. This was pre-WorldCom, pre-Enron. I know I don't look that old. But while I was there, people uncovered all kinds of allegations that raised a lot of questions, and it really led me to go into law school to try to encourage whistleblower protections and laws, which led my path to going to Taxpayers Against Fraud eventually. But one of the things that struck me then, and it struck me throughout my career, and certainly in private practice, is that while we think everybody knows about the False Claims Act, goes back to what Dave was saying earlier, there's a lot of people who don't. I had a case actually in Erica's old office in the Northern District of California involving a very large pharmaceutical company. And our client was the product manager of a drug that worked for a very small percentage of the patient population. But the company allegedly was marketing it for everybody, right? So it was a drug that really should have been a niche market drug, but if you market for people that it doesn't work for, it could lead to False Claims Act violations, which was certainly our allegation. And it was very interesting as the case went along, and it's true for so many of them, that our client was really the only person who stepped forward. And you see large companies in which lots of people should be raising their hands, and there's only one or two who are stepping forward, and there's others that are stepping back. And that's certainly true in the healthcare arena, where we see hospital systems that are accepting kickbacks from doctors, or doctors are receiving kickbacks from health systems, or receiving kickbacks from pharmaceutical companies, medical device companies, a lot of money flowing this way and that way, but very few people step forward. And I think a lot of it flows because of the lack of information or education about the False Claims Act. We assume that everybody knows about what's out there, but the reality is that very few do. And those that do don't understand, or they have a misconception. And even more concerning is the lack of knowledge in our bar. So we mentioned 300 TAF lawyers. That's 300 for the entire country, right? So we're talking trillions of dollars protected by 300 lawyers. And you add to that the people at Main Justice and the ACE attorneys are out across the country. It's smaller than a large law firm. We're tasked with protecting trillions of dollars and protecting whistleblowers against large corporations, large law firms on the other side. So that case, in my own experience, just reminds me that we have a lot of work to do. And when I came back to TAF, my focus, I told my staff, I was like, I just want to do public education. Like, can I do a podcast, a YouTube? I don't know how to tweet, but can I figure it out? Maybe I'll do a TikTok dance. Like, I want to do all the public education stuff, because when I was in private practice, like, that's where the need was, and it still is so true. So yeah, I think about my client, his name was Brian Shields, and how he was the one and only, and it's the shoulda, coulda been who should have stepped forward that I think about. And I think it's because of a lack of knowledge, and that's our responsibility.
That is such a great pivot to our next question, Jed. And Jeb, I really like to ask you to answer this first, Jeb, about if the law was different at the time of a case that you could have in mind that helped you start to see, beyond the False Claims Act being a fantastic law, that it still needed improvement. What was the case for you that helped you see that there was time for change? And if the law was different, there would have been a different and better outcome for your client? Yeah,
it's part of the False Claims Act amendments that recently made it out of the Senate Judiciary Committee and is now headed to the floor. By the way, that amendment those amendments made it out of the Judiciary Committee by a vote of 15-7. During a time in which we're evenly divided, have anything come out of any committee by that margin highlights the real concern that Congress has about a law, and it's certainly true here. So the amendment that, there's three real basic ones that are in that package, but the one that's important, relevant here, was this protection for former employees, right? So the False Claims Act provides anti-retaliation protection for employees. Some courts have rightly or wrongfully read that provision to not protect employees after they've been fired. So former employees not receiving anti-retaliation protection of the False Claims Act is a huge concern, because that's the reality of the world we live in, right? People leave an employer, they move on to somewhere else. Somebody realizes later, Johnny filed a False Claims Act case against me, or had brought obviously this person was bringing a case, and then phone calls are made, people find themselves unemployed and blackballed in the industry and unable to find a job. The reality is, unless that certainty is put in place, people don't file those cases. And the cases I think of are the cases that should have been filed, but they couldn't because people didn't feel a level of comfort. There wasn't this level of certainty that they were going to be protected under the False Claims Act. And without certainty, people don't speak up. So yeah, there's multiple times in which I could think of people who had legitimate concerns about fraud, but whenever they did the calculus about, what does this mean for my career, especially when they were in that circumstance of being a former employee, those cases tend not to get filed, and that's the detriment of the public fisc, to patient harm, and to all of us. So yeah, I think about all those people that I've talked about over the years, where I'm like, you know what? I don't know. You're 38 years old. You have 3 kids at home. You live in the middle of nowhere. You're working for the only employer. I don't know if I would file a case if I were you. And that's a shame, and it's a real detriment to all of us.
All right, Jeb. Well, you didn't tell us a story, so I have to move on to Erica to get a juicy one about a case that would have turned out differently if the law was different at the time. But very good information, though, Jeb.
I think I'm trained, right, as a government attorney, to not reveal narrative stories, right? That's like the way we are trained. So I might disappoint in that way, but I think
I got you cornered.
With respect to thinking about the amendments, right, and thinking about a topic that has been on the mind of folks in this area for a long time, and there's a litany of cases I could list with respect to kind of the materiality element, right, of the False Claims Act and the Escobar decision, and thankfully the amendments that are working their way through to try to fix maybe some problems that have been coming after the Escobar decision. And so I think the piece of that has just always struck me, and I've seen it turn cases away at the same time, right? Like either government may have to decline something, or a Relators Council won't recommend, for all the reasons Jeb was saying, going forward because of these materiality issues. In particular, I find it particularly disheartening when there's a defense of a government payment, continued government payment, right, after maybe some allegations were, or even sometimes knowledge of the fraud or misdoings are known to somebody within the government. And I want to kind of take a step back for why that's so concerning, that argument. And this is something that both basically on day one at DOJ and now at day one of my BU healthcare fraud class, I had to learn, which is, if you're talking about Medicare, you have to understand how the system works, and how it intersects with all of our public policy and health policy. And what we do when I walk my students through this at BU, we examine the balancing act that Congress and federal agencies have to play when thinking about the Medicare program. And there's kind of, if you want to break it down to be super simplistic, there's kind of 2 options, right? There's review everything that comes in. We're talking, hundreds of thousands of claims a day, right? Review them all for fraud, at least some level, before you even pay anything out, right? Or you do what's called pay and chase, right? And so the reality is that's kind of the decision that CMS and others are having to make. And if you do the former, the system grinds to a halt, and the patients and good doctors who are trying to do the right thing are the ones who fall victim, right? And so it is established there's going to have to be some sort of pay and chase in this system. And that is where the FCA is so important. And I had to learn this as a DOJ attorney. And I would see it, right? In that I'd say I could advocate to suspend payment sometimes, but if we're talking about a rural hospital, right? Or a federally qualified healthcare center, where if you stop any line of that payment, even if it's only for a portion, right? Or that is going to affect the whole healthcare system in that area. Similarly with some drug companies. And that's a very real problem. I was just talking about it again yesterday in my class. It affects the kind of settlements that happen. It is a reality that we all work with, and it's something, but it's particularly frustrating to say the least when I see that twisted into a defense. And I'm really grateful that I think the courts are actually starting to understand that more. There was a little bit of, it was all over the place immediately after Escobar. But I do think the case law is starting to settle in the right direction. But I do think that without a legislative fix, we're going to continue having these fights. And I'll flag that it's super critical to get it, because the same arguments are going to come up with the pandemic fraud cases. And that's a ton of money. And we all know, it was even talked about last night, right? That it is a big problem. And I think, to head off any arguments, I do think actually that the programs are in a decent position legally under, certain decisions like 11th Circuit Bibby decision, because there were some safeguards, there's some guarantees that were in there, but we don't want to take that risk, right? And we need to get this fixed. So I hope I don't disappoint. I told a story for the first one, Siri, and I'll have more, I promise.
Well, I mean, I'm very happy that you brought up the fraud in the COVID-19 recovery programs, because that's something the Department of Justice has recognized whistleblowers for contributing to, helping them stop people from stealing money from the government under the guise of providing PPP loans and other types of exploitation of this crisis, which everyone has been, thank God, getting used to hopefully seeing pass by us. Dave, I think you are here to save the day, David, and I want to hear a story that would have turned out differently if the law was different.
Sure, but I do want to say that what Erica just said about what it means for materiality and how it impacts these cases. I mean, I think that was one of the best explanations of materiality and why we need that amendment that I've heard. And so I thank you for that. And for you, Siri, I'm going to tell a story, but I'm going to disappoint you, because I'm going to point back again to the fake biofuels case. So I know we've already talked about that. And I want to talk about it in the context of the case went criminal. So and you might think, oh, well, that's a great thing that happened for the American people and the taxpayer. The government prosecuted the fraudsters and they locked them up. That it was like one of the first ever criminal prosecutions of a CEO of a publicly traded company under Sarbanes-Oxley, a criminal prosecution. There haven't been many of those. Great. But what's the impact on the whistleblower's case? And it gets incredibly complex and difficult to pay an award to a whistleblower under the False Claims Act if there's a parallel criminal investigation. And the reason for that is, and there were two things that happened in this case. One is the government has to rely upon forfeiture orders in order to freeze the assets of the defendants. Well, in this particular case, they took a year to investigate or more. And by the time the government got to the grand jury and indicted the fraudsters, they already knew that there was an investigation and they spent a lot of the assets or hid them. So there wasn't a lot left at the end to recover. And then when you add to that the fact that they got a criminal conviction, and as part of their plea agreements or sentencing, they got restitution orders where these defendants were required to pay, each of them were required to pay something on the order of $56 million each to compensate for the losses to the victims. Yes, the Department of Justice and the EPA and the IRS were listed as victims on the restitution sheet, but there were also a lot of individuals who were harmed by the biofuels fraud. And under our restitution statutes, priority must be made to pay the individuals before they can pay a government entity. And because of the collections issue, at the time, by the time you're done, there wasn't enough money collected in order to pay any of the government entities. And there wasn't enough money to pay any of all of the victims who were individuals or companies. So that presented a huge collections issue. And you can't under the False Claims Act say, okay, the government out of that $56 million judgment collected $10 million, give me the whistleblower or relator share on that $10 million you collected in the criminal. That's not part of the Civil False Claims Act. So we filed our motion for summary judgment, and because they were all criminally convicted, we got a ruling and we got paper judgments of $69 million against each of these defendants, but none of it can be collected through that process. So if it weren't for a publicly traded company being involved and there being an SEC whistleblower proceeding where our client can get paid, where under Dodd-Frank Act, the criminal restitution recovery is a related action, and the SEC will pay an award based on collections under that process. Whereas if all we had was the False Claims Act, it would be a zero collection case. Even though we got a $69 million judgment, even though the whistleblower helped the government put these people behind bars. So I know that's not in the legislation, but I think moving forward is something we need to look at seriously about how the victims statute and the restitution statute interplay with the False Claims Act to make it easier for whistleblowers to collect on the money that's collected by the government through criminal restitution.
Oh my gosh, David, I get so excited by that story because, you know, the related action rule that the Securities and Exchange Commission recently proposed definitely helps whistleblowers that are in the position that your client was, where they helped with two different programs that have whistleblower rules, but one of the programs would have left them out in the cold. And because of the Dodd-Frank Act, they still were able to continue with their life despite the serious disruption that the successful whistleblowing caused. So I'm going to ask you guys a kind of curveball because we're doing really well on time. And the issue kind of came up a few times with us, and we're talking about how complex these issues are, how interrelated they are, how many different agencies there are, how the law is constantly changing, and how few attorneys there really are. So I want to know, Erica, if you were to talk to a friend who needed an FCA attorney and you were not able to represent them because of some conflicts, because you already knew everything and everyone involved, how would you help that friend choose an attorney?
Well, it's interesting. I found myself finding referrals for employment matters. So I'll kind of let me from there. And I think, you know, I think you do need somebody who knows this area of the law, right? I welcome opportunities to co-counsel with folks who don't, and then they can launch after. But I have to say, you know, 10 years and more than 10 years in, I'm constantly calling people and constantly having to kind of understand not just the case law. I think what makes this so tricky. So I guess this is one point. You really have to understand the practical side, like the things that David was just talking about. You have to understand what an intervention decision is and what a pre-filing statement is and what a disclosure statement is and what's going to actually work and what's all the behind the scenes, how do certain offices work with each other. And I hate to, you know, say if it's not really that it's inside baseball, because I think anyone who practices in the area comes to know these things. It's just experience, right? And so that's one reason I frankly joined the firm that I did, is I was really impressed with the experience, you know, of my now partners. But so one is that I would say that, you know, you do need to find somebody who has experience in the False Claims Act, if that's the law we're talking about. Many of those firms do have SEC and other things. And so you want to make sure, though, that they also are going to be able to evaluate, as David said, you know, whether you can file under multiple programs and or also if you have employment issues, right? If you've been terminated or sidelined or anything, you want to make sure they either partner with a good employment firm or really have experience in those areas. So that's kind of the big picture view. And then I think it's, you know, it's important to feel comfortable with your attorney and to have a real relationship. I mean, that's something I really value in my new role, are the relationships I build with the clients. This is a long haul. Even in the best of cases, if you have a speedy case, I had a 2-year case, which I was getting congratulations from, you know, from everybody, because I was like, 2 years, that's amazing. But, you know, that is the exception, right? And it's under seal. So you can only talk with your lawyer about it. And there's going to be some challenging parts, and there may be other parts that happen in your life, in things that are just going to happen in those 5 years. So that's what I would say is, it's less about pedigree, although obviously you want somebody very accomplished, but it's also about being able to connect with that person. So I would look for that.
That's great advice, Erica. Yes, going for an attorney is a very personal and interpersonal experience that requires so much trust in a very complicated environment. And I think the fact that you highlighted the reality that these cases are sealed is really important, because it's a unique experience to work with a lawyer on a matter that you can't discuss with your loved ones. And it's extremely stressful. So Jeb, tell me, how would you advise someone who's considering one of the members of TAF to represent them and picking between the 300 that you could offer?
Yeah. I always think of, there's a lot of really great lawyers out there who really are zealous advocates, really represent their clients to the best of their abilities. But if you're running east in search of a sunset, you're going to be heading in the wrong direction, right? So yeah, those who have been there, done there, got the t-shirt, have experience, know the government, know the case law, know the players, that's invaluable. And Erica is absolutely right. Whenever we look at cases and we try to identify the people who really are the big players and the movers in those areas, we try to look for cases that are similar to the fact patterns that we see, right? So I always play this game. I get the Wall Street Journal and I read it every morning, and I look at cases and fact patterns that are identified there. I'm like, I wonder who's behind this. So usually there's some False Claims Act case in just about every issue, or at least an SEC matter. And you could usually identify by the fingerprints, right? These are the kind of cases that Eric would bring, or Bob, or Dave, or whoever, just because of the kinds of cases. So if I was in the whistleblower shoe, I want to reach out to the attorneys who have done the kinds of cases that match the fact pattern I'm in. And then the other thing, Erica is absolutely right. It's a marriage. We had a case that took 12 years to settle. So this is, you're going to be talking to this attorney late at night, sometimes after work, updating them on the conversations that happened that day. They're going to be your counsel. And during this time of increased isolation, it takes on an even more important role. So somebody you get along with, that you trust, that you have faith in. And then, somebody who has your best interests in mind. There's lots of ways that you can make money in this world. And being a false claims qui tam attorney isn't the easiest way. You have to really have a passion for this area. And by and large, the group of attorneys who are in our bar, they do it for the right reasons. So making sure you understand their interests in your case is really, really important. So yeah, been there, done that, have the right temperament for you, and really match your principles. I think it's a good checklist.
Thank you, Jeb. Yeah, I'm just thinking about the concept of a marriage with your attorney and the 12-year commitment that it takes, and a lot of the as David brought up, stigma around the awards and how certain people think that whistleblowers are in it for the money, as if it's an overnight payoff, and whistleblower attorneys are in it for the money, as if the checks just roll in right away after your first intake conversation, and it's just not like that. So David, would you draw from your experience since 1988 working at a whistleblower law firm, running a whistleblower law firm, and over time, what have you gleaned about how potential clients can make the best decision for themselves regarding the attorney they choose to work with?
Yeah, and I happen to deal with the principal partner involved in the initial review of intakes for our firm, so I see this on a daily basis. And declining a good case is a very difficult thing to do for a lawyer. But the number of requests that come in, you have to find a way to filter them, right? You can't pick up the phone like in the old days. When I first started practicing law, the phone would ring. There was no internet. Or the internet was just starting. I'm not that old, but the phone would ring, you would talk to the person and spend time on the phone with them. And you could chew up a lot of time in the day talking to people who want to tell you their story. And typically what we do is, you have to find a way to, it's like an interview process, right? Which is a two-way street. We're interviewing the client and the client's interviewing us. And we have this wonderful thing called the internet, where you can gather a lot of information about law firms, their website, start with their websites, see the kinds of cases that they did. I think that's a good advice. But then it's just like, again, there is a need that can't be matched by the bar. So, it's like, yeah, if we can't help you, I try to refer people either to the group that, the organization that Neil is trying to get going, where he's trying to match people to lawyers. And before that, it was, okay, do we have other organizations that are out there that, for retaliation cases, for example, you can go to NELA's website, the National Employment Lawyers Association, and they have a website by geographic area. You can, search for lawyers in that area, but also doing your own general web searches is good. I know that TAF has a directory, I think, that's available, so you can see whether or not there are, TAF members who, and then you have to take it a step further and do the research on the firms themselves. You can't just pick up the phone and call a law firm. I don't even know in today's pandemic world whether or not you'll even have a person at a law firm to answer a phone. A lot of this stuff is through the internet, filling out forms, asking, describing your case. And then, if you're a whistleblower looking for a law firm, find the best way to describe your situation. One of the most difficult things that I have is when I read these requests for representation coming in is, it's like, who's the defendant here? What type of case is this? It's like, I have to perform a conflicts check on my end, which most people don't understand before we even talk to the person. And there's a lot of information that lawyers need to know. So what I've done is I've developed a list of questions that I send out to people saying, they might send something in very general, but you have to send in information that will convince the lawyers who are in high demand that this is a case that they want to do.
Yes, high quality information is definitely very important, and there's so many steps a client has to take to prepare for a case. The idea that we need more attorneys has come up a number of times during this conversation. So I really want to encourage people to continue to reach out for educational resources and consider joining this field of practice. If you are an attorney, you can get involved, join TAF, check out our, follow NWC, check out everything we have to offer. Erica teaches at BU. I teach at Northeastern University. National Whistleblower Center takes interns from Georgetown, Northeastern University, University of California. I know that Colapinto also accepts interns for work experience to see what it's like. And we really do need to build an army of lawyers that are ready to help support clients that are interested in coming forward. And I really want to share the website for our intake form that you can fill out and be connected with Neil and his team. So it's report-fraud-now.info. And if you go to that website, report-fraud-now.info, you can fill out your whistleblower information. And you can also just go to the NWC website, whistleblowers.org, and then click on the little red button on the upper right-hand corner that says Get Help. So National Whistleblower Center is not able to process any intakes, and it's really important that you use that Get Help button to be connected with Neil and his team, who can take in your intake and help refer you to an attorney that they believe can help you in your case. I want to pivot towards a dreamland, because we all joined the legal profession with aspirations and hopes and goals, and sometimes this world can be daunting, seeing cases that aren't working out or fraudsters not being held accountable because the law should be different, can be frustrating. So we touched a little bit on the False Claims Act and its value, and why there's certain things that need to be changed as have been posed in Senator Grassley's fantastic amendments. But now I want to give you a chance to talk about your dreams, unless you want to go back to the amendments and things that need to change and why the law is important, but I think we hashed that through. What would you, if you could snap your fingers and change the False Claims Act to make it better, to improve it for the clients that you've interacted with, to help more people bring cases and stop taxpayers' monies from being exploited by criminals, what would you do? And I'm going to start with David.
Okay. And if there's anyone from the Department of Justice listening to this or tuning into this, I don't mean this as, blatant criticism of the Department of Justice. They're very good public servants, conscientious, etc. And I want to direct but I think one of the things that we face when we deal with the False Claims Act, which is a statute and it has to follow certain procedures and certain steps that are technical, etc. But what we need to do is, I think that everyone in this community would benefit if the DOJ took a step back from their role as viewing DOJ as the law firm representing the United States and the US interests in these cases, and deal with policies that are more whistleblower friendly to encourage whistleblowing, because I think sometimes the two collide. And give you an example of that. I mean, one of the, there's a lot of policies that get developed over the course of time because the DOJ views itself as the lawyers for the government, and it can discourage relators. Give you an example. Relator share is always a big contentious topic, where in cases you can fight over relator share over 1 or 2 points at a lower end of the scale when, how often does DOJ ever award the maximum amount? And, when you look at the annual statistics, it's like, well, that seems like a low number when you start doing the math between the whistleblower recoveries and the total gross that was recovered in key 10 cases. And how can that be? And a lot of it is stuff that is just built up over time. And a lot of this will require, really retooling the culture of the Key 10 program at DOJ. And I don't know how to communicate that. I don't know the solution to it, but I can give you a contrast. When Dodd-Frank was passed and the SEC, which had a horrible reputation and how it treated whistleblowers before the Dodd-Frank Act was passed, they retooled themselves as an agency around the whistleblower. And that took leadership from a chair of the SEC, Mary Jo White, who was a former federal prosecutor. And, she was, for many years, headed the corporate law department of a huge Wall Street law firm. And when she was appointed by President Obama, a lot of us in the whistleblower community feared that she was going to take the corporation's side in implementing the whistleblower program. And that would be bad for the law, it would be bad for the whistleblowers. And the opposite occurred, because she gave a speech. I think the actual title of the speech was the SEC as the whistleblower, where she talked about how valuable they viewed the role of the whistleblower in their enforcement actions. And they were going to create every priority of the enforcement division of the SEC to advance and protect whistleblowers. And that's what I think is missing from the DOJ, which has, developed its playbook on how to deal with False Claims Act cases over time, where there's a policy or there's a memo, or, nobody even knows how some of these policies get proposed or whatever. And it's like, did anyone stop and think, what's the impact on promoting whistleblowing and encouraging whistleblowers when these steps are taken? So I don't want to go too much into the weeds on that, but I think that there needs to be direction from the top. Usually these things come from the top that set the example and set the priorities. Another thing is when you look at the priorities that the Justice Department is taking, when I look at the False Claims Act statistics, they seem to be devoting a lot of effort to developing False Claims Act cases without whistleblowers. And yet there's a lot of cases that are meritorious that don't get intervened. And they shift that litigation burden to the whistleblowers and their counsel in cases where the government really should be doing more in those cases. And why is that? I think a lot of it has to do with, what are the priorities? And I don't know how we can communicate that message. And I don't know if it would take a law or whatever. This seems more policy related. But in the day-to-day operations of this law, I don't think they're living up to the goal of encouraging whistleblowers. And I think more could be done to change the culture around that.
Very, very well said. Recently, the Whistleblower Network News published an article about the incredible success of the FCA program in terms of reclaiming misappropriated funds to the taxpayers, but the increasingly declining amount of monies that are paid out to whistleblowers. So the government's getting more money, but whistleblowers are getting less money. And that definitely correlates with what you're saying, David, about the priorities and the messages that are being sent. It's a major disincentive. It stops people from being eager to file False Claims Act cases when the government doesn't join, and then when the government is stingy about rewards. The Securities and Exchange Commission is a great example of rewarding whistleblowers abundantly and robustly, has issued, isn't it $1 billion of rewards under some really great leadership, and recognize the value of whistleblowers, even to the extent that their recent proposed rules do acknowledge the reality that they will not be capping awards based on a high dollar amount in order to continue incentivizing individuals to come forward. And you want to add to that, David?
Yeah. Let me just say one more thing to that, because that's a great example of, and it relates to the relator share struggles that we have under the False Claims Act. The SEC and the IRS and the CFTC, they all got it really quickly after they started their program. We need to give out big awards. We need to give out, and they're not quibbling over, percentages. A lot of these, like when we did the Bradley Birkenfeld case at the IRS, they gave him $100 million, $104 million award at 26% or something like that. They weren't quibbling over the percentage, saying, oh, and he went to prison. He got that check when he came right out of prison, but it was an early thing. They wanted to make a statement that we are going to pay a big award. And when we deal with these other programs, they're not quibbling over cutting back a percentage on the related action part of the award. And they're not quibbling over dollars and cents on percentages. They want to give a good award. Whereas when we go into discussions with DOJ, it's like, well, we'll start at 16% or 17% and then fight, like the Dickens, to try to get it up to 18, 19 or 20% or whatever the number is. But that's their view. It's like, why are you concerned as the Department of Justice not to pay a decent award to this person who reported a fraud that you weren't investigating before they filed the case? I would think you would, but that's the type of thinking that I think is an example of what I'm talking about, is that if you're looking at it strictly from the perspective of the government protecting its interests, thinking that keeping the awards to whistleblowers smaller is protecting the taxpayer, it's short-sighted, is my point.
Couldn't agree more with you, David. Now on to Jeb's dreams. What are you dreaming of, and what is TAP dreaming of to improve this law?
Well, I don't know if I speak for TAP all the time. Right now we have an acting assistant attorney general of the civil division. I think that if we look at DOJ, a lot of great public servants there. I think that they would really benefit from having an assistant attorney general in charge of the civil division who has experience in the government, but also has experience on the relator side. And I know of nobody who is harder working or smarter from the government than Erica Hitchings. So I continue my campaign to make Erica the Assistant Attorney General of the Civil Division. Until then, we have an acting Assistant Attorney General. We do the best we can with what we have, right? But setting that aside, and that's my dream, my second favorite dream involves actually tax fraud. So when the False Claims Act was amended in 1986, they put in a tax bar, basically saying that the False Claims Act doesn't reach tax fraud. And I talked to John Phillips, who was in the room with Congressman Grassley, or Senator Grassley and Congressman Berman at the time. And it really was one of those things where they just thought, you know what, we're going to have a lot of people coming after us from the defense industry, all these big players. Let's not really upset the entire business industry by adding tax fraud. So it was more of a political move than anything else. And since then, this view that tax fraud should be outside of the reach of the False Claims Act has kind of been accepted until 10 years ago. And New York decided to put in a modified tax bar with very important guardrails to put in place to see, will this plane fly or will it crash? And it has flown to the atmosphere. It really is remarkable, the success of the New York False Claims Act tax bar, modified tax bar, to allow relators to partner with the government in uncovering, detecting, and prosecuting tax fraud. It has been a game changer for New York, and other jurisdictions have followed suit. Right? We see DC has passed a similar law. Maryland has passed something recently. Other states are like, you know what, you're right. We could do this in a way that's sensible. So here we are at a time with unprecedented government spending, a tax gap of $1 trillion, and the False Claims Act doesn't reach tax fraud. It's very short thinking on our parts. And the answer that Congress keeps offering up is we need more auditors. We need to put more bean counters in place. Well, we know that it doesn't work unless you have people behind corporate walls deciphering what's happening. And we know that the IRS whistleblower program, while well-intentioned, has not lived up to its promise because it's not a public-private partnership as we see under the False Claims Act. You really need to have that partnership, that investment of private resources to invest in these cases to move them forward. So my magic wand, I would wish upon the False Claims Act fairy to modify the tax bar and encourage whistleblowers and their counsel to invest in these cases, and let's help close that tax gap. Until then, I continue my campaign to make Erica the Assistant Attorney General of the Civil Division.
It's so wonderful how you highlight the power of state-based laws and how incredibly essential they are to our democratic system. We have the states to experiment with different approaches to enforcing our laws, and having these state-based SCA versions and variations will hopefully have an impact on the federal level as federally elected officials start catching wind to their efficacy. So I'm really happy you brought that up. Thank you, Jeb.
Yeah.
And Erica, if Jeb's dreams do come true and you become the Assistant Attorney General and could even control the law, what would you do to change it and make it more effective?
Understood. Well, I do love DC, so go from there. But well, I guess I'll hit two things. One is kind of more of a heads up, right? Kind of things that I see on the horizon. That's not so far on the horizon right now. As we were talking about the element of materiality before, but there has been an attack on the element of scienter brewing, and it has percolated very much through the surface recently with the 4th and 7th Circuit decisions, building off of a non-FCA Supreme Court case called Safeco. That's an important point. And I think this is a thing that is working its way through the courts, but I think is so also frustrating and potentially really problematic. In fact, so problematic that a dissenting judge within the 4th Circuit said that it was the current decision that when the defense side was essentially neutering the False Claims Act. And the reason in his view and ours or mine, that it is doing that is it's eviscerating. There was a decision that essentially eviscerates the Congress's intent with the scienter provision, which really means that, to establish liability under the False Claims Act, you can show it in a multitude of ways, right? It uses the word knowingly. That is defined explicitly, right, in the statute, which is lovely, actually, really nice to have there. It's actual knowledge, reckless disregard, or deliberate ignorance. And if I was teaching, my slideshow would have like literally an ostrich with its head in the sand image right now. And it's essentially wiping out those second two, at least, provisions, and even arguably lacking out the actual knowledge aspect of it, because as Judge Wynn noted, it essentially allows a post hoc rationalization. If you can find an attorney who can find a smart enough, creative enough argument to make 6 years later, you might be able to get out of False Claims Act liability, even if you had actual knowledge. And that's a concern that those of us who are looking to bring these cases and who really are thinking about the issues have. And so I'd encourage folks to be proactive and continuing to fight that fight in the courts. It's critical. I'm not going to stop bringing good cases because of it, but I do worry about the chilling effect it will have on others as you're talking about additional attorneys, or perhaps, if folks who don't have as much experience wade into it without realizing, we could get some unfortunate decisions. And I find it, it's not good in my view for the American taxpayers. And so that's the big picture, like what keeps you up at night if you're a relators counselor or maybe even a government attorney, I'm not sure. But I will on a more discreet note, and something I've learned as I've stepped out of my government role and into representing individual whistleblowers or potential clients. And this harkens back to what Jeb said earlier on about the cases that aren't being brought because it's not safe necessarily. He brought the idea of a former employee in particular, and that fix is in the works. But there's a lot of confidentiality provisions and severance agreements that explicitly say you can't go to the government, or if they don't say that, they make it really hard for you to potentially recover if you do. The SEC has come out, and as have several state, at least I know of one state, FCA, that makes that impermissible and just shuts that down. Because I worry a little bit. I've seen cases that have come to us, potential cases that are absolute frauds that I would have taken on. But those provisions made it not viable and too risky for the person to proceed. But even I worry more, and Jeb, you hit the nail on the head with this, about the chilling effect, right? The average person knows that they signed some sort of confidentiality agreement, maybe even at the start of their employment, which was innocuous enough. Often it is a severance agreement. And I just think about the imbalance, like that's not even getting to lawyers to analyze the enforceability. And so I think that it's a really easy, straightforward, logical fix. And I think, and I have seen the impact of the SEC's approach when we do review when we review severance agreements, right, that are being proposed or already been signed by potential clients. The lawyers have responded. They carve that out. They don't want to be in violation. And so it really it is one of the few times that I've been like, oh, look, people follow that because it's so discreet. The SEC has enforced it before. It's a straightforward rule that's actually quite easy. It's easy for me to say, it's easy to implement, but it's been done before and it works. And so if that were present with False Claims Act cases, I think we would see more high quality cases, and arguably high quality cases from well-placed relators. Because if you're talking about severance agreements that are too good to pass up, you're talking about people who are at the executive level typically, right? And who have the most information to share, but often find themselves unable to do so.
Yeah, Siri, can I jump in here? Yeah, so Dave mentioned earlier the annual DOJ statistics on the recoveries of the False Claims Act over the past year. It wasn't highlighted by DOJ, but I did want to highlight for this group, what Erica's talking about isn't theoretical. This is real life. And we're seeing the numbers play out. Last year, key TAM filings, new cases were at a 10-year low. And this is during a time of increased government spending, right? Think about how much money's gone out the doors over the last 24 months. But new key TAM filings are at a 10-year low. It doesn't make sense unless you look at all these things that Erica and Dave and I have been talking about today. We're talking about legitimate concerns that are causing Relators Council to say, you know what, I wouldn't file this case. It's just not worth it. And until these things are fixed by Congress, people can continue to say, you know what, this is just not worth it. It's not worth your career to step forward on the False Claims Act unless some of these things are put in place. So 10-year low on key TAM filings while government spending is at all-time high. It just doesn't make sense except for some of these things that we're talking about today.
Well, that's right. And I think that, if you look at the statistics from the SEC program, their tips of being submitted are at an all-time high. I mean, they just keep, they're going up and the key TAM is going down. That's why I think that we need to take a look at these other programs. What are the features of these other programs that whistleblowers feel comfortable with and are willing to file claims? And, like, for example, under Dodd-Frank, you have a right not only to be confidential, but also to be anonymous. Whereas under the False Claims Act, when I tell clients or potential clients that at the end of the day, the likelihood is that your case is going to come out from under seal and your name's going to be known, that is in and of itself a chilling effect for a lot of people, because they don't want to, they don't mind reporting it to the government, and they don't mind, if the case is successful and they're going to get a share of a big recovery or some kind of recovery, they don't mind their name being known at that point. But to be publicly known, and the case, most of the cases don't get intervened in and are not successful. And if you want your name attached to that on the public record is a difficult sell sometimes.
Yeah, we have covered so many issues today, from the anti-retaliation provisions that should be applied to former employees, to NDAs, to awards being too small, to the DOJ having to change its policies when it relates to the value of whistleblowers and how important they are to be a partner in enforcement rather than just somebody who's viewed as a simple witness. I really, really, really appreciate this discussion. And I was wondering for you all, thinking about, for example, some problems that we can see on the horizon. We're about to go into the Q&A period, but looking at the NDA issue, looking at agreements that are stifling people, chilling effects like fears of being retaliated against, or fears of not being awarded and having your career destroyed, fears of payouts taking too long or cases lasting forever. What are the words of encouragement that we can offer people who know about wrongdoing, who know about frauds, who know that somebody's ripping off the government in a big way, who are maybe well-positioned, who possibly are watching right now, who just don't know what to do or are looking for some encouragement to come forward? And I'll start with Erica because she looks like she has something on the tip of her tongue.
I was gonna say you should start with Jeff. So one thing I would say, I know I've plugged it before, but one of the I really recommend the Fraud in America podcast for a couple of reasons. There's kind of there's a whole string of them, right? They're all interesting, but the ones I look for are the stories from whistleblowers, right? So there's a very compelling one I've listened to, right, from Ellen Coons, who brought forth their case against Halifax Hospital, which was a really successful case, but she talks about the reality of it. But it also has some great words of encouragement. Cheryl Meads, there's an incest whistleblower who had a very compelling narrative that has stayed with me and motivated me. And she was correct me, right, Jeb? You were the interviewer, so I'm sorry to steal your thunder if this is what you're going to talk about. But I think it was Mia Guzman. Is that correct? And she spoke about literally what drove her was being able to put her kids to bed at night and know that she had done the right thing. She said it far more eloquently, and it was truly from the heart. I've heard her speak in person. She ended up not getting any or much of a reward because of some of the issues David was highlighting in bankruptcy. And, despite, the opioid crisis, right? We know the ramifications of that, and incest was prosecuted, but individuals too. But, so that to me, coming from her, who was young and put a lot at risk, and I assume suffered some consequences. I didn't represent her. So honestly, that it is, so maybe that wasn't the best story of her individual, but despite all of that, she really did say that it brought her a personal comfort that could not be met in any other way. And I will say that, there's a lot of us, there's a lot of people trying to do the right thing out there. And there's a lot of lawyers who want to help you do it, right? And sometimes it may not be filing the case, and but it may be finding a lawyer who can help you find the right person in the government to share your information with. And that's something we can't always do it. We have limited time and limited resources, but we have done and we will do. And it's, very rewarding and appropriate for us because it's what needs to happen. Right. And there may be different reasons that person can't file or is not going to be likely an intervention. So it's not worth the business case, right, for a lawyer to take it on. But we can do some limited representations or other things. And I think that's, I don't find much resistance to that, right, in this bar. I find a lot of people really wanting to help. And so I would say there are a lot of people who want to help you. And I have through TAF, I've met a community of whistleblowers, not just whistleblower attorneys, and the support they provide for each other. So I'll kick it over to Jeb because he's more intimately involved with that. Has been really inspiring to me. And I didn't have insight into that within the government. And so that is something, it has really rounded out my understanding of the law, but also of the realities behind it, right? I knew all the legal issues coming out of the government, but now I understand the big picture much better.
Yeah, actually, right after this, at 4:00, I have a meeting with our advisory group of whistleblowers, right, to pick their brains on how we could better tell their stories and their struggles, and really to connect, inspire, and empower other people to step forward is really the whole focus of fraud in America, but also taxpayers against fraud more generally. But when it comes to putting on my old hat in private practice, deciding what cases to get involved in, a lot of times it's a matter of saying, will this case be successful? And a large part of that is getting the government interested. And one of the way that we try to figure out whether or not the government's interested is seeing, are we reinventing the wheel here, or are there other cases where the government has intervened and settled cases that are like ours? So we look for other cases where the government is intervening. That gives us encouragement to step forward. And then the other thing that the Justice Department has done recently that's really, really helpful is they're highlighting, look, we're interested in these kind of fraud cases, right? Cybersecurity, we have a task force. We want these cases, bring them to us. They speak at our conferences. They come and they're interested in writing blog posts or spotlighting what they're doing. Just today, the Attorney General put out a statement saying they're interested in cases involving the Russian oligarchs, right? Any kind of way to reach them under our laws. There's all these areas. The OIG work plan comes out every year where OIG says, we're really, really worried about these kind of fraud schemes. To us in the relators bar, that's saying, all right, so when people call, this is exhibit 1 in my disclosure memo going to the government. You guys are interested in this. Look, right here, OIG is very interested in this kind of fraud. So, there's all these things that we're looking for on the relator side to give us hope and assurances that if our relator files a case and risks their career, that the government is serious about it. So we're always looking for tells from the government. So all those things are very, very helpful.
Dave, would you like to add anything to that, or should we jump into the question?
Well, I would just add that despite all of our criticisms and pointing out the weaknesses of the law, it's still the most effective law for whistleblowers, period. End of story. And what we're talking about is searching for ways to make it better. And the False Claims Act served as the model for these other programs and these other laws. And there's a good reason for that, because it works, because it has brought in billions of dollars for the taxpayers over years. And what we want to do, what from our frustration as the practitioners, and I think I think the whistleblowers who we represent would share it, is that when you look at it, it's like how much fraud there is out there and how much is being left on the table by the government for not pursuing it for one reason or another, whether it's a technicality or a policy reason or whatever. So I wouldn't discourage people from filing these cases because the law is bad or anything like that. We're looking for ways to make it better and more effective.
Right.
Well said.
I echo that. I mean, we're here because it has so much power, right? And it's a matter of making sure that everyone goes in with their eyes wide open and fully understood. When you ask about what does a good attorney do, there shouldn't be, you never can say there's going to be no surprises because that's life, right? But, there shouldn't be big ones, right? That are that could have been predicted, right? And I think that's, you can hear that we're so in the weeds, right? But, it is, one of my partners says she, fell in love with the False Claims Act. And I think about that because it's both fascinating as a lawyer, right? I mean, when people say, well, why do you like doing what you do? Because I kind of, people move around into different subject areas when they're new attorneys. And I just started with the False Claims Act. I was like, well, I'm doing defense industry stuff. I'm doing sleep center, I'm doing hospitals, I'm doing everything. And then I'm dealing stuff with that's going up to the Supreme Court in terms of the legal questions. And it's like, I'm battling the biggest firms that are out there. So as a lawyer, if you're watching, it's fascinating and it's got employment aspects and, so it's really great. But I would say, for a whistleblower, there's a lot of rewards, right? And I'm seeing that for our clients, right? There's some challenging times. But I certainly would rather, if I were in that position, go through it with somebody by my side than just struggle and try to figure out what I should or shouldn't be doing, what I can or can't be doing. So don't hesitate to reach out. A lawyer will tell you, maybe filing a case isn't your best bet, but they can still give you advice. Maybe it is, and that gives you more protection than you would have if you didn't file. So you never know. I would say consult with someone.
It's interesting. Dave mentioned, CFTC, SEC. There's other agencies, FTC. All these groups are now. All these different agencies are looking at the False Claims Act as a model. The states are also looking, right? So in 1986, the Modern False Claims Act came onto the books, and then a year later, California passed the False Claims Act, and since then, 30 other states have joined. An interesting point: Wisconsin repealed their law. And then just recently, they realized the mistake they made, and they're putting it back on the book. So this is a law that works, and states across the country are recognizing big states, small states, red states, blue states. This is the law that needs to be in place to protect your government dollars. So.
Yes, and it's so important to break down the statement of, government leaving money on the table. And when you say that means tax dollars that are not being used for their intended purpose. That means taxes that you pay, that I pay, that everyone in this audience who's in the United States pays, being used for a purpose other than what we voted for them to be used for. And it's a major threat to our democracy when those kinds of situations are arising. And what Erica points out about how it's so broad that whistleblowing impacts everything. It touches every single aspect of our lives, and it's an anti-corruption mechanism, it's a human rights mechanism, it's an environmental protection mechanism, it's a gender equality mechanism, it's a racial equality mechanism, it's an economic equality mechanism. So when you do this work, you really are changing the world. And I mean, it's so meaningful that President Biden recognized whistleblowers and applauded people who came forward and had the courage to speak up. Most recently, Francis Haugen, who was at the State of the Union yesterday and recognized during his speech. And, these chilling effects that we discussed are powerful, but not insurmountable. And, we will continue to improve these laws. And it's so important that we all get together to discuss it. So we had a very practical Q&A question. Now we're going into the Q&A portion. I just want to point out to anybody who's in the audience who needs an attorney, please go to the intake form and fill it out to seek an attorney. You can go to whistleblowers.org and check it out. You can go to report-fraud-now.info to fill out a disclosure form. And you can also go to the TAF website, the Whistleblower Law Collaborative website. You can go to the KKC website. All these attorneys that we have before you do have intake forms, and you can reach out to them and try and get help. We are not able to provide any help via the chat. In fact, putting information about things that you may be aware of into the chat may compromise your confidentiality and safety, and we highly discourage that. But please use the intake form. And with that in mind, one question that is very practical that's coming up in the chat is, what can an individual do, just a step-by-step, about filing a False Claims Act claim, starting the process? How do you know, what do you do? I think Jeb has instruction.
That's a great question. The first thing I would do is, and you put your finger right on it, we talked about this before, is reach out to a lawyer. Before you start making lots of copies at the copy machine, making phone calls from your employer's phone, sending emails from your employer's email system, that night at home, reach out to a competent lawyer who has experience in this area and let them guide your steps. Anything beyond that is you risk the chance of exposing yourself to your employer and really jeopardizing your career. Everybody's situation is a little bit different. The False Claims Act is a very complex legal area that needs competent counsel to walk you through. I always have my little statue of Moses here. See my Moses walking people through the promised land, right? Here's my David whistleblower. Just to remind me, right? We're here to guide people to where they need to be. And if people are not comfortable stepping forward on their own, and they shouldn't be, they need to make their first step be to contact counsel.
And can one of you explain a little bit about how secure it is to communicate directly with an attorney and the kinds of protection that a person has when they do share their information with an attorney while in the pursuit of legal advice, whether they decide to hire that person and work with that person or not? Maybe Erica?
I'm happy to. I also saw David probably has a lot of experience with this as well. But the short and sweet, right? Big picture is, if you are seeking representation, even at that initial email, which I know can be super scary, email or intake form, whatever version, or phone message, right? Whatever you choose. If you are seeking representation, even in that slightest way, that from that moment on, right, that conversation and all future conversations are protected by the attorney-client privilege and confidentiality duties that we have. We do run a conflicts check quickly, so we don't get too far down the road to find out if we have another client who might, either be opposed or at least just be having a competing claim. And so we'll be careful to not get too much information. And even if we do, we have ways to keep that, all separate. But, and we try to always remember to remind folks who are calling us, and, people come with different levels of comfort, right? Some are really uncomfortable sharing even the defendant's potential name. We have to get that for conflicts, but we won't press on too many details until they develop that rapport. We totally understand that. But I think it is super important to understand that. And that's a duty that we have, right? And that means somebody surprised me because I hadn't thought of this, right? That they asked, I said, well, I recognize you can't, it's privilege or it's confidential, but like, what if I decide not to file a case? Aren't you going to want, if you know about this, to go, find another client and proceed, or like, we can't use that information, right? Like it is like, I'm not going to go expose you that way. I won't get into all the details, all the different rules and state bars and everything, but David's nodding his head and has more years of practice than I do. So feel free to chime in.
I think all that is great advice. And the one of the frustrating things on our side is not being able to get enough information at the beginning because that rapport hasn't been established. And I understand that. And so it is something that is needed. I mean, it's like, how can you help someone if they can't tell you what the problem is? And that's, and it builds up over time. That's why we've tried to develop ways to ascertain that information quickly so that we can do the check, so that we can see if it's a case initially we're interested in. And if we're not interested, we'll just stop and we won't use that information anywhere else. But I think that is a major concern that people have is exactly what you've described. How do I know you're not going to use this information to help somebody else or one of your other clients? And it's not permissible. And that's the reason we want to know who the defendant is, so that we can make sure we're not doing that.
I'm so happy you all explained that, because going to an attorney is really the safest route for actually analyzing the information you have and seeing if you really do have a violation that the government can take action on. And it's something that's so protected, it's so secure, and you don't have to know everything about the attorney right away. You can get to know them, you can take your time, you can ask the questions you need to ask without having any risk to yourself, because they are not allowed to share or send around or use your information for anything other than your advising. So, you know, attorneys are here for your best interest, and it's really important that you reach out to one if you have information. But let's look at the attorney side. So a question from the audience is about, what would you say to people who are attorneys who are considering going into this area of work, whether they're law students, whether they're active attorneys right now? What would you tell them to look at in considering getting involved with FCA actions? I see your smile, Deb.
Well, I have to say, so we also have a fellowship and interns, and we're trying our best to encourage people to get in this area. And it's really, really exciting to see former fellows and interns of TAP who are now relators counsel or working at DOJ. And see, I get emotional. It's just so cool to see that play out. Erica touched on it earlier. You got to find great mentors. When I decided to go in private practice, I reached out to two mentors of mine, Ken Nolan and Marcella Auerbach, who were longtime and are longtime practitioners in the law. It's very helpful to have people who've been there, who've done that, who can be great sounding boards, who can be reality checks on your enthusiasm coming out of law school or coming from a law firm or the government, and just learn, right? I tell our fellows, your job is to be a sponge. Learn as much as you can right now. And this area is rewarding, helping people who are going through a rough time and fighting the system and standing up to the corporate Goliaths. I don't think there's a better area of the law. And when I came into this practice area in the early 2000s, one of my mentors, Peter Chatfield, told me, he said, you should take this month and read every single published circuit court opinion. And I did it. It was 30 days of reading circuit court opinions, which you could do that. Now it'd take you a long time. But even now, it's not really a whole lot compared to like constitutional law or immigration. It's an area of the law that one or two court decisions, as Erica talked about earlier, really can sway this area of the law in a big way. So it's an area of the law that's fast changing, impacts the entire government spending, government money's everywhere, and you really can make an impact. So there's my pitch for area of the law. It really, really is a life-changing experience.
I'll chime in for law students, right? So if you happen, or even if you're a young associate somewhere, I mean, if you're a law student, one of the things I thought I got great experience with the clinics of the law school, and that kind of saved my mental health in law school, frankly, was being practical and doing casework, and I loved doing that. But what I didn't do that I realized later would have been really valuable is extern in either a judge's chambers, or if for this area of the law, frankly, a U.S. attorney's office or a state. And specifically, typically, if you're looking at that, I only knew about the criminal sections at U.S. attorney's office. And I knew I didn't want to be a criminal prosecutor, so I just didn't even think about it, right? And here I ended up, my dream job, I said, was to work at DOJ, but I never even sought it out in the first 3 years of law school, because I wanted to be on the civil side. I didn't really think about that being available all around the country. And so there's some offices that have more affirmative civil work, False Claims Act work, than others. But I think if you go and you know enough about the civil division, you apply and you say, because I supervise some of the interns we had in San Francisco, and you express an interest in those cases. I mean, they're only taking on law clerks. They're doing it to get a little help, frankly, but really because they enjoy supervising. They want to serve the community, the law school community, and they want a diverse set of applicants who understand what the DOJ does for the future. When those folks are ready to, maybe they don't get the job right away out of law school, but they can come back a few years later. And so if you have any interest or have taken one class or even just gone to a few seminars, and you let a U.S. attorney's office or a state AG's office that has a practice area on this know that, I think you're going to get amazing opportunities. And I've seen some of those by talking to students beyond the ones that I supervise. So that's and also there are more firms like ours that are taking on law clerks. It's not something that's advertised usually because we're small firms and the same level of consistent hiring. But I've definitely sent folks, we've hired students in the past, both as for credit, we'll do it through the local law schools, right? As official externs, or we'll do sometimes do paid positions in the summer. But if we're not doing it that summer for whatever reason, I've sent them to other firms who I know will give them a great experience. So we really have an interest in fostering that. I'm going to put in one final plug. If you're an associate or even a partner, there have been people who have made great strides from the defense bar. You learn all the law, right? Excellent advocates on that side, right? And many of our friends and others, right, that we went to law school with, or we've done cases in the government with or against, make the move to the public service in the government, even if the relators bar isn't your spot. Like it was so rewarding being there, and the government can benefit so much from folks who have come from either the relators bar or the defense bar to bring all those skills to bear. And also make the move to our side. We'll happily talk to you.
If I could just add one thing, and that is I'm really surprised. I think I mentioned earlier, I'm kind of surprised that it's not taught in more law schools as a subject area. And when I look back on my legal career, I mean, it's one of the areas of law where you can actually do it in a couple of ways. You can actually create a firm and represent people doing this law, or you could do it in conjunction with employment law, or in conjunction with, I know a lot of firms that practice in this area have created a FCA Key Tim division of their firm, and their primary cases are either securities or personal injury or whatever. But it is such an area that you can have success and make a living and create a firm, whereas there's very few areas of the law where you can just go out of law school and do that sort of thing. And but unfortunately, there is a lot of fear that, like, even people that practice employment discrimination law are afraid to take a whistleblower retaliation case because they are afraid that they'll be fish out of water. And I wouldn't recommend that someone who just does employment discrimination cases take a Key Tim case. You should partner with lawyers who, like what Erica said earlier, co-counseling cases with people who are experienced in the area. We do that a lot as well, and it can be very beneficial. But it's just mind-boggling that law schools will not teach this across the board, because it isn't just representing whistleblowers either. It's people who go into careers in compliance in corporations. And so much of what whistleblower law does touches so many fields, whether you're representing the whistleblower or you're trying to investigate their concerns internally through a company. You got to be exposed to that, and it's not being taught.
That is so.
We have two teachers here who are.
Yes, we're really patting ourselves on the back here. That is so true. And I really like that you highlight the fact that even if you're not planning on being a whistleblower or relator's attorney, it's important to know the way that these laws work, particularly the False Claims Act. If you're in-house counsel, if you're representing any type of business that does contracting with the government, if you're a government attorney that manages the contracts of the government, it's important for you to understand how the False Claims Act works. A, if you're in the government, to catch fraud, but B, to make sure that you're not inadvertently engaging in fraudulent activities or approving fraudulent activities because you don't know how the law works. Sometimes there are cases where people are simply not telling the government about certain things or avoiding certain facts that ultimately can result in a False Claims Act action against them that, you know, for a new attorney might be a surprise. So it's really important to make sure you know the laws that you can be held accountable under, as well as know how to enforce them if you're on the relators or the whistleblower side. So that's really important that you raise the general applicability of this knowledge. So we have one last question from the audience, and then we're going to wrap up. We're going to turn to our keynote, which starts in 10 minutes. It premieres on YouTube. And the final question is a one-word answer that I'm going to ask from each of you. The audience wants to know 3 qualities to look for in an attorney when you're thinking about filing a False Claims Act case. So each of you get to pick one word. And I'm going to start with Erica, so she has the most choice. And then after that, you can all pick a different word. So Erica, one word for a quality that someone should look for in an attorney when they're thinking about filing a False Claims Act case.
Thoughtfulness.
Thoughtfulness. All righty. And David?
I'd say perseverance.
Perseverance. Yes. And Jeb?
Judgment.
Judgment.
That was my next one.
Thoughtfulness. Yes. Yes. Thoughtfulness, perseverance, and judgment. And those are all qualities that I think you 3 have. And it's been so wonderful to have this conversation with you. If you're interested in taking action to support the amendments that Senator Grassley will be discussing, there is an action alert at the whistleblowers.org website. You can send a letter that we've drafted for you to your representative and tell them that you care about the False Claims Act and you need to see these amendments that we discussed today being adopted, enacted, and put into force. So this is something that we all can agree is a critical issue for the safety of our economy, for our democracy, for our environment, and all the other areas that we touched upon today. And we are all available on social media, and you can check out our live tweet on Twitter at Stop Fraud. You can visit whistleblowers.org. You can check out TAF online, Kohn, Colapinto online, Whistleblower Law Collective online. You can find us in your digital world, and many of us are available and receptive via email. So thank you so much for joining us today, and I really appreciate everyone signing up for this event. It is a preview to what we'll be seeing for National Whistleblower Day this year, so please RSVP for that. Also, the link will be available on Twitter. And outside of that, anybody else have any closing remarks? Thank you so much for your time.
Thank
Thank
you.
you.
Very much.
A lot of
All right,
fun.
well, check out our YouTube premiere with Senator Grassley, airing in 5 minutes on YouTube at the YouTube channel for National Whistleblower Center. You can find it. We have a link on Twitter as well, and there should be one in the chat. Have a great day, and thank you.
Thanks so much.
Thanks, Harry. Thanks, Dave. Thanks, Erica.
I wish I could be with you in person, because I think most of you know how I love to be people that make good use out of one of the most important pieces of legislation I've ever got passed. So that's the False Claims Act. This year, as you know, marks the 159th anniversary of the enactment of the False Claims Act. Now, maybe you think I just said I was there in 1863. No, I was not, but I have improved that law. So that in the Civil War time, it was signed into law by President Lincoln. Today, the False Claims Act is the federal government's most powerful tool to protect taxpayers' dollars and to root out waste, fraud, and abuse. I led the update in 1986 to strengthen this law and empower whistleblowers. Since that update, the False Claims Act has helped recover more than $70 billion of the taxpayers' dollars. And I'm talking about taxpayer dollars lost to fraud. In 2021 alone, the Justice Department recovered 5 6/10 billions thanks to the False Claims Act. Over the past year, massive increases in government funding to address the pandemic have led to an unprecedented level of fraud and theft of government funds. As a result, the False Claims Act is more important now than ever. Unfortunately, the False Claims Act is constantly under attack by industries looking to make it easier to make a dollar out of defrauding the government. And I know that makes you sick. Their army of lawyers do their very best in these industries to twist the meaning of the False Claims Act and exploit misrepresentations and misinterpretations from the courts. This is exactly what has happened and is happening in the last few years when many courts have contorted a Supreme Court opinion to say that if the government pays for a claim despite knowledge of that fraud, then the fraud wasn't material and I guess, can't be prosecuted. We all know that is not how things work in the real world. There are many reasons why the government would continue paying a claim despite knowledge of fraud, such as national security concerns, fear of creating a drug scarcity, or simply that they don't have the legal authority to cease payments. Last year, I introduced the False Claims Act amendments of 2021, addressing the latest attack on the False Claims Act. My legislation would clarify that the government can still hold fraudsters accountable if other reasons existed for their continued payment. Additionally, my bill makes it harder for the Justice Department to dismiss a whistleblower's claim by requiring that the whistleblower state their reasons and present evidence. And it extends protections against whistleblower retaliation to post-employment retaliation. These changes will continue to provide the federal government and whistleblowers with the means to continue to recover billions of dollars per year. I'll always keep fighting to strengthen the False Claims Act to combat fraud for years to come. Lastly, I want to leave you with this. The False Claims Act is the most powerful tool the government has to combat fraud. And it's the brave whistleblowers who make the law successful. Whistleblowers are the government's eyes and ears in uncovering and deterring fraud. Without whistleblowers, the False Claims Act would simply not work. So I'd like to thank you for inviting me to speak today and for your continued support of the False Claims Act and whistleblowers across the country.